Okay, good afternoon, everyone, and welcome to the Lubar Center and Eckstein Hall. My name is Joseph Kearney, and it is a great privilege for me as Dean of Marquette University Law School to introduce this year's Boden Lecture. Let me begin by recalling the individual in whose memory this lecture stands, the late Robert F. Boden, a Marquette lawyer from our class of 1952, a practitioner in Milwaukee, a Marquette law professor, and for some 19 years, dean of this law school. As that brief list perhaps intimates, Dean Boden was an exemplar. This was so for our students and his faculty colleagues. It was also the case for the profession more generally, especially in Wisconsin. It seemed right then, a decade or so after his death in 1984, that Marquette University Law School should create an annual lecture as one of the ways that we remember Dean Boden. It enables his legacy to continue and all of us to benefit from it. Our tradition for this annual occasion has become to invite a distinguished academic not otherwise likely to be here and from whom we can learn. And we can learn much from Ingrid Wuerth here on her first trip to Milwaukee. Professor Wuerth holds the Helen Strong Curry Chair in International Law at Vanderbilt University, where she also directs the school's International Legal Studies program. She is, as these titles may suggest, a leading scholar of foreign affairs and public international law. Her scholarship has appeared in the law reviews at Texas, Northwestern, Michigan, Chicago, and Harvard, in addition to any number of journals specifically focused on international law. Professor Wuerth sits on the board of editors of the American Journal of International Law and is a member of the American Law Institute and the State Department's Advisory Committee on Public International Law. Some evidence of her prominence is her selection in 2012 as reporter for the Restatement Fourth of the Foreign Relation Law of the United States. Let me add that Professor Wuerth is committed to civic education as well, with some of her work, for example, appearing at the very well-regarded Lawfare blog published out of Washington, D.C. We are grateful that today she is with us. For the title of her Boden Lecture, Professor Wuerth has selected International Law and Peace Among Nations. Won't you please join me in welcoming Ingrid Wuerth?
Thank you so much. It's a great honor to deliver today's lecture in honor of your former dean, Robert F. Boden. Thanks to all of you for attending, and particular thanks to Dean Kearney for his generous hospitality throughout the visit. So, as you know, my topic tonight is international law and peace among nations. Now, it might seem like a poor fit for a lecture honoring Dean Boden. I didn't know him, but I've read that Dean Boden was passionately dedicated to teaching law students about the actual day-to-day practice of law. And he believed law schools should be focused on that sort of professional training, not on policy questions, and certainly not on preparing students to be architects of society. Now, international law involves a lot of policy, and some international law involves structuring or building a global society of sorts. And yet, it also demands outstanding technical lawyers, the very ones that we train, you at Marquette and me at Vanderbilt. Beyond that, international law addresses many topics that lawyers and leaders in Milwaukee and Nashville should be educated about, and even, I might add, passionate about. Those topics include my subject tonight, so I think Dean Boden would approve, or at least I hope he would. The importance of peace among nations is clear as we look back in history to the devastating losses of World Wars I and II, and as we look forward and we contemplate the possibility of nuclear conflict with Iran or North Korea, or the possibility of a maritime war with China, or war with Russia in Ukraine and Eastern Europe. Indeed, many foreign policy experts size up the world today and conclude that the risk of a major interstate war is significant and growing. One threat comes from what has been termed the Thucydides Trap, after the historian Thucydides, who wrote the history of the Peloponnesian War in 431 BCE. He argued it was the rise of Athens and the fear that this rise instilled in Sparta that made war inevitable. And it's not just Sparta and Athens. Looking over the past 500 years, historians today argue that when a power rises quickly to threaten or displace a ruling power, the most likely outcome is war. The key variable in this analysis is a rapid shift in the balance of power, generally measured by relative GDP and military strength. 12 of the 16 cases in which this has occurred ended violently. Today, obviously, the threat is posed by China, whose dramatic economic growth threatens to displace the ruling power, the United States. Indeed, on some economic measures, China has already done so, and China is also making tremendous investments in its military, narrowing the gap between it and the United States. History, at least, suggests that this pattern is a dangerous one. Beyond the specifics of the Thucydides Trap, both China and Russia are revisionist powers, meaning they are unhappy with the global distribution of wealth and power, and both would like to be restored to at least regional dominance. Robert Kagan of the Brookings Institute and formerly the State Department warns that we are, quote unquote, backing into World War III. Some of the Chinese and Russian ambition is territorial, as in the East and South China Seas for China, and Ukraine and Eastern Europe for Russia. But beyond that, China and Russia both view themselves as victims of hegemonic power wielded by the West, in particular legal power, exercised through international law in the form of what they view historically unfair treaties, or to use the phrase that the Ottoman Empire used, the capitulations, treaties imposed by force by Western powers historically. So both China and Russia perceive the liberal post-war order in general, and the United States in particular, as thwarting their objectives. At the same time, as Robert Kagan argues, there's a declining will and ability from the United States and the West to maintain the dominant place that they have held in the international system since 1945. So other foreign policy experts argue that despite their differences, liberals and conservatives in the United States have shared three basic foreign policy principles in the post-war era: a faith in democracy, the belief that America's security is enhanced by broad and deep alliances around the world, and the belief that open trade brings global prosperity. Again, people argue that a retreat from these post-World War II values means that the risk of war grows. A variety of prominent commentators have advanced this thesis, including Fareed Zakaria in the Washington Post not so long ago. But there is some good news. I see you're looking a little bummed out about that, which at least tells me you've been listening. So let's turn to the good news part of the talk. Despite these threats and even the gathering storm clouds, we might say, today we continue to live in a period dubbed the Long Peace, meaning that the post-World War II period is one in which there has been a dramatic reduction in armed conflict between nation states. During that same period, and extending further back to the end of World War I, a central and overarching goal of international law has been the eradication of interstate war. Now, the place and the role of international law in creating and sustaining the long peace is neither straightforward nor uncontested. But as I will demonstrate, there are strong reasons to think that international law has helped generate the peace. And unfortunately, the features of international law most likely to have contributed to peace are today under threat, in part from unexpected quarters. So in this lecture, I will briefly describe the international law designed to limit interstate conflict. I will offer an evaluation of whether and how international law has been successful in doing so. And then I will address current threats to peace which come from changes in international law. But first, I'm going to tell you what international law is. For those of you who need a refresher course, or maybe you never even took international law, but I don't want to hear that. Let's just call it a refresher, right? What is international law? International law is the law that governs relations among nation states. It's the law that applies to states themselves, and by states I use the term to mean countries, right? It's the law that applies to countries in their interactions with other countries. There's a lot of transnational or foreign law that is not international law. The most straightforward example of international law is a treaty, right? It governs the way nation states interact with each other. All right, with that in place, I turn now to the international law designed to limit interstate armed conflict. Following the devastation of World War I, the Covenant of the League of Nations sought to prevent war by requiring member nations to use a compulsory system of dispute resolution. But the Covenant did not prohibit war outright. Indeed, war was still permitted as a method of interstate dispute resolution, just as it had been for centuries. International law was very permissive with respect to the use of war to resolve international disputes. Until 1928. The Kellogg-Briand Pact changed that. With the Kellogg-Briand Pact, which is a treaty, countries pledged that the solution of all disputes which might arise between them shall never be sought except by pacific means. That pact, which came about in large part through the efforts of a visionary corporate lawyer from the Midwest named Salmon Levinson, was not an immediate success, right? Indeed, just a decade later, World War II began, and World War II was started by those very same countries who signed the Kellogg-Briand Pact. So much for international law. As World War II raged, US lawyers and diplomats worked again to end war for all time, this time by drafting what would become the Charter of the United Nations. The UN Charter has as its centerpiece a prohibition on the use of force. That's Article 2.4, which forbids the threat or use of force against the territorial integrity or political independence of any state. The Charter also created the UN Security Council, which has the power to enforce that prohibition through coercive measures, but it also, of course, gives a veto power to the victors of World War II, China, France, Russia, UK, and the United States. Unlike the failed League of Nations, the UN has near universal membership. Today, the United Nations has an enormous agenda of worthy causes, from protecting human rights to combating diseases such as AIDS. So it's easy to forget that at its inception, the core purpose of the UN Charter was to prevent war. Those drafting the Charter, for example, rejected language that would have made human rights obligations legally binding. All right, so now for the second question. Has it worked? As I said, we are today in a period that has been dubbed the long peace, meaning that the post-World War II period in which there has been a dramatic reduction in armed conflict. The precise role of international law in reducing interstate armed conflict is not clear. To begin with, there are questions about how international law is enforced. Why, in other words, would it be effective at all? I will return to that particular point, which I believe some of you probably have in your mind. I will return to that at the end of the talk. But there's other problems with concluding that international law has caused the long peace. There are other factors that have likely contributed to peace among nations, including trade, foreign direct investment, perhaps the advent of nuclear weapons. These are all things that may have reduced the threat of war. Various empirical studies do show a strong relationship between international legal commitments and a reduction in armed conflict over territory, although proving causation is obviously difficult. We know that during this long, peaceful period, territorial conquests, which have been outlawed by international law, have been radically curtailed. In the years before World War II, an average country could be conquered, expect to be conquered once in a human lifespan. After World War II, an average state can expect some kind of territorial conquest once or twice a millennium. Now, the period between 1928, when the Kellogg-Briand Pact took effect, and the end of World War II, that period obviously involved a lot of territorial conquest, suggesting, as I already have, that international law doesn't work. Interestingly, however, almost all of those territorial conquests were eventually reversed. Why? One possibility is the acquisition of territory by force violated international law after 1928, and those conquests were not recognized by other nations which demanded their reversal. They were in the end reversed after, in the period following 1928, and that is not a pattern we see before 1928 at all. A book called The Internationalists, published just this week, which I highly recommend, reviewed in the New Yorker, for those of you who read the New Yorker, also reviewed in the New York Times Book Review, argues that it was the Kellogg-Briand Pact of 1928 that caused the definitive turn away from interstate war. Note, and even though that norm may have only taken place after the UN Charter was put in place, that it was 1928 that was the breakthrough. Now notice, if that book is correct, a Midwestern corporate lawyer trained at Lake Forest College of Law had the vision and determination to push through a multilateral treaty that had a transformative effect on world affairs. Now, some were skeptical about the importance of 1928 and the Kellogg-Briand Pact, especially in light of the devastation of World War II. Some people argue that it was not 1928, but 1945. And I would like to approach the question from a little bit different angle to get a little more purchase on thinking about the role of international law in reducing interstate conflict. And here I want to turn to something that may sound boring, but it's really exciting, and that is the political science literature, which is rarely discussed in international legal scholarship. So let's put aside international law for a minute and ask what we know about the cause of war. Right? What causes nations to go to war with each other? The empirical data makes two things clear about this question. First, war is most likely to occur when countries have disagreements about territory. Trade disputes, ideological disputes, other kinds of disputes are far less likely to lead to war than disputes about territory. The second is that war is least likely to occur between democracies. These two findings are called the territorial peace and the democratic peace, respectively. Working backwards, they tell us that if international law reduces conflict over territory, or if international law creates democracies, it will improve the likelihood of peace among nations. So I'll put the democratic peace to one side for a minute. Yes, that's two things that I put to one side, both of which I will return to. Let's talk for a minute about the territorial peace. International law has put in place a variety of mechanisms specifically to reduce conflict over territory, including, obviously, Article 2.4 of the UN Charter and the ban on conquests, but also a host of other doctrinal rules with fascinating Latin-sounding names like uti possidetis. These are all designed to preserve the sanctity of borders, and there are a variety of international institutions designed to reduce conflict over territory and borders, including the International Court of justice. Now, if these legal rules and these institutions make territorial conflict more costly to states, and I believe they unquestionably do, even if we don't know how costly, right? So if they make territorial conflict more costly to states, then they reduce the incentive to engage in territorial conflict over time, which is strongly correlated with peace among nations. All right, I think that's some good news, right? We have this international legal architecture, it's doing something, and we have some strong reasons to think if it effectively reduces conflict over territory, it's making some progress. But that brings me to my third issue, which is contemporary threats to peace among nations. I've already mentioned the geopolitical threats. There are also threats that come from changes in the international legal system. Here, you probably expect me to explain how President Trump has undermined international law. Actually, I don't think he has, at least not in most ways. And for tonight, at least, my target is elsewhere, somewhere you're probably not expecting, and that elsewhere is human rights. The post-World War II international legal order has been characterized by peace among nations, but also more recently by the rise of international human rights law. Human rights have purported to transform international law, in part by changing the very definition of state sovereignty to mean not just effective control over territory, but also the use of state power to protect and promote human rights. This is a powerful idea. States are not fully sovereign when they violate human rights. That is a powerful idea, but it is also a dangerous one. The transformation of state sovereignty to include a respect for human rights led to an explicit call for the use of force to prevent widespread human rights violations. The use of force is acceptable if states are not fully sovereign when they are violating human rights. Sometimes this is called humanitarian intervention. Sometimes with a slightly different context, it's called responsibility to protect. The doctrine rose to prominence during the 1999 NATO bombing of Kosovo, led by President Bill Clinton. The bombing was for humanitarian purposes, not, the US said, for territorial conquest. The action violated Article 2.4 of the UN Charter, but was defended by some countries and many individuals as legal because it served to protect and promote the human rights of Kosovar Albanians. The UN Security Council was unable to act because Russia, with its permanent member's veto, was a longtime ally of Serbia, the state in which Kosovo was located. Russia's view, the unrest in Kosovo was a domestic issue, not one that justified international intervention. These events led to an extensive debate about the wisdom and legality of humanitarian intervention. China, like Russia, did not shy away from calling the NATO action a violation of the UN Charter and a violation of the universally recognized norms guiding international relations. China says it caused serious damage to the authority of the UN Security Council. The Kosovo intervention, however well-intentioned, and remember from Russia's perspective it was not well-intentioned, has had a significant and destabilizing set of ramifications. The bombing campaign led eventually to Kosovo's declaration of independence from Serbia in 2008. Not surprisingly, Serbia and its allies, especially Russia, condemned the Declaration of Independence and do not recognize Kosovo as a nation state even today, meaning that Kosovo will not become a member of the United Nations anytime soon. Kosovo set a precedent for bypassing the UN Security Council and Article 2.4 of the UN Charter when countries are acting for a humanitarian purpose. Russia has come to welcome that precedent, citing it to justify Russia's use of force in Georgia and Ukraine. Crimea, which was once part of Ukraine, is today Russian. Official Russian explanations for the actions against Georgia and Ukraine make repeated and clear reference to the precedent set by NATO in Kosovo. Russia said in both cases it was acting to protect a Russian minority from human rights violations at the hands of the Georgian and the Ukraine governments. Note that many people in Russia, some people in Europe, and the rest of the West did not condemn this analogy, even if they condemned Russia's action itself. So today, the primary threat to peace with Russia is the increasingly militarized border between NATO or NATO-allied countries and Russia, which includes now thousands of NATO troops doing military exercises, the most since the end of the Cold War. Humanitarian intervention has thus helped generate the rising risk of conflict over territory today. President Trump's airstrikes in Syria have further contributed to the erosion of Article 2.4 of the UN Charter. You will recall that last April, acting without UN Security Council authorization, President Trump ordered airstrikes in Syria in response to Syria's use of chemical weapons. A deplorable and horrific act by Syria, to be sure. Unlike the bombing of Kosovo, the Syrian airstrikes were not the effort of a regional security organization such as NATO. They were unilateral on the part of the United States. Supporters of President Trump's actions from across the political spectrum, and there were many supporters, argue that Article 2.4 of the Charter needs to be updated. We need, according to this view, a more nuanced approach to the use of force under international law, one which is carefully calibrated to permit the use of force in response to humanitarian atrocities. We must be clear, however, about the risks. Perhaps the degradation of the UN Charter-based limitations will weaken the international law prohibitions on the use of force, making regional or global conflict with China, North Korea, and Russia more likely. Today, of course, the South China Sea is usually cited as the world's leading conflict-prone area, and a border dispute continues to simmer between China and India. China was unusually and, in fact, alarmingly restrained in its comments about the Syrian airstrikes. Breaking from past practice, China did not directly criticize U.S. airstrikes as violating international law, a dramatic departure from China's position 10, 20 years earlier. Why? Who knows? Perhaps China's territorial ambitions in the South China Sea means that it has begun to see Article 2 of the UN Charter as hindering its foreign policy objectives. Many people in the West assume that we, meaning the West, can set the rules for appropriate departures from Article 2.4. Russia has made clear in Eastern Europe that it will use those departures to its own ends, and China may be next. So there's a second way to think about the dangers presented here, and that's the sidelining and weakening of the UN Security Council. The use of force in Syria, Ukraine, Kosovo, all in the name of human rights and humanitarian intervention, also serve to undermine the authority of the UN Security Council itself. And as I've already mentioned, that's a fact that has been lamented by China in a variety of contexts. But the Security Council is a key forum for resolving other threats to interstate peace, such as Iran and North Korea. China, which of course is key to containing North Korea, highlights its constructive role, China's constructive role, in developing UN Security Council resolutions designed to deter North Korean nuclear programs as well as their missile program. After all, it is international law that provides the basis for imposing sanctions on North Korea to limit its nuclear ambitions in the first place. The United States returns, of course, to the Security Council when we want to impose sanctions, as we obviously did this week. To undercut the authority of the UN Security Council is potentially to compromise our ability to solve other problems through the actions of the Council. In the case of Iran, too, international law strongly supports U.S. policy objectives of preventing the acquisition of nuclear weapons. Sanctions imposed by the United States Security Council for violating international law are a large part of what led to the 2015 Joint Comprehensive Plan of Action which relaxed some of those sanctions in return for Iranian concessions on its nuclear program. Undermining the work of the UN Security Council makes peace more difficult to achieve in this context as well. So the human rights-based doctrine of humanitarian intervention allows states to sideline the UN Security Council when they have their own objectives that they want to meet. There are other ways, too, to think about how human rights may have had a deleterious effect on the Security Council. Since the 1990s and early 2000s, the Security Council's mandate has expanded greatly. It includes more and more human rights-related matters. With that growth comes two potential problems. One, heightened expectations, which go unfulfilled. We could call these credibility costs. The second is a greater perception of selectivity and bias. We might call these polarization costs. Examples abound, including from the effect of human rights work on peacekeeping. There's evidence that suggests that peacekeeping is now working less well, that we have folded a human rights mandate into the peacekeeping function. But I want to focus on another example, which is Libya. In the case of the 2011 airstrikes in Libya, the UN Security Council did authorize the use of force to protect civilians from the threat of massive human rights violations. Russia and China abstained from, but did not veto, the relevant UN Security Council resolutions. So airstrikes in Libya, fully consistent with international law, were used by NATO to help the Libyan rebels oust Gaddafi. Again, in the name of human rights. President Obama said the dark shadow of tyranny has been lifted, and with this enormous promise, the Libyan people now have a great responsibility to build an inclusive, tolerant, and democratic Libya that stands as the ultimate rebuke to Gaddafi's dictatorship. That's a difficult sentence to read if you know anything about what's actually happening in Libya today. But putting that to one side, which is a lot to put to one side, but putting that to one side, the regime change aspect of the intervention in Libya. This is the regime change, right? This is the using airstrikes to provide cover for the ultimate ousting and death of Gaddafi. The regime change aspect of the intervention appeared to many countries as the use of human rights and humanitarian issues as a smokescreen to achieve the removal of Gaddafi, a result explicitly desired by the West. As one writer puts it, the use of force in Libya fueled speculations as to which other countries are also likely candidates for intervention by the West. As a result, cooperation between Russia and Western countries on other issues have become more difficult after the events in Libya, in particular cooperation on Syria, right? This is an example of polarization in the UN Security Council where cooperation on other issues becomes more difficult because we have a human rights generated disagreement. Consider this alarming example. When Russia effectively annexed Crimea in violation of Article 2.4 of the UN Charter, many nations in the UN General Assembly refused to condemn this obvious violation of international law. Why? They saw it as justified payback for the West's selective enforcement of human rights law in Kosovo and especially in Iraq, a war also justified in part based on human rights. So the UN's actions with respect to Libya also led to what you might think of as credibility costs. Right? At the same time as we had the airstrikes in Libya, the Syrian government was using increasingly violent measures to quell domestic unrest. The Syrian conflict escalated, as you know, into a devastating civil war, killing hundreds of thousands of people. The Security Council was unable to take meaningful action, but because it had acted on humanitarian concerns in the past, the Syrian rebels were expecting and hoping for military support through the UN, which was hamstrung. This expanded mandate of the Security Council over mass atrocities and other human rights violations creates a credibility problem when the Security Council is hamstrung by political differences and accordingly cannot act in response to some atrocities, although it acts in response to others. So there's another way to think about the relationship between human rights and international law and how they relate to peace among nations. The problems that human rights have created for the Security Council are mirrored to some extent by the problems they have created for international law as a whole. Human rights have expanded the core of international law, just the way it's expanded the mandate of the UN Security Council. So the true primary sources of international law, I am a law professor, I can't help but tell you what the sources of international law are. They're treaties and custom. They've become broader and more expansive over the past 30 years. More and more human rights are protected by binding international law. And the success of this effort is clear. International law now regulates a vast array of human rights-related conduct. Today, there are 64 human rights-related treaties, just counting those under the auspices of the United Nations and the Council of Europe. Those agreements have 1,377 human rights obligations in them. Not only are there a lot of obligations, they are very routinely violated. One commentator sympathetic to international human rights has quipped, "If human rights were a currency, its value would be in free fall." Now that may or may not be good for human rights, but the point I'd like you to think about is a different one. The potential effect of this expansion on international law as a whole. Widespread violations of some legal norms make it more difficult to enforce others. So as an analogy, consider the broken windows theory of crime prevention. Right? It posits that widespread violations of law, even mundane and apparently trivial legal rules, can lead to other, potentially more serious violations of law. Similarly, widespread violations of human rights law, just as in the broken windows context in the domestic arena, may signal that no one really cares about violations of international law as a whole. Now, accountability is, of course, a fundamental concern to public international law because, as I've already mentioned, it lacks a centralized enforcement mechanism. So the idea that there's a lack of accountability and that no one really cares when international law is violated might be especially damaging to a weaker legal system like international law. So that, of course, brings us back to one of the topics I raised at the beginning that I promised that we would come back to, and here we are, back to it. How can international law quell territorial conflict when international law lacks a centralized enforcement mechanism? International law works by making violations costly in some way for the violator. These costs can be in the form of sanctions imposed by other countries, the withholding of benefits, or even actions by the UN Security Council itself, as when Iraq invaded Kuwait. But UN Security Council enforcement measures can be vetoed by any one of the 5 permanent members, making them of limited effectiveness. Much more important, generally, are the enforcement measures taken by individual states and the concern that potential law-breaking states have about violating international law and the costs that that will impose on them, be they political costs, economic costs, or military costs. But 2 things are key to this system of compliance: the reputation of states for compliance and the reputation of states for punishing violators. And the point about human rights is just this: states' reputations for compliance and for enforcing international law decrease as a whole when there are a large number of unenforced international legal obligations out there. That's what's happened with our 1,377 human rights obligations. So I said I'd also come back to the democratic piece. Right, so the democratic piece says states tend not to go to war if they're both democracies. Human rights are associated with democracies. Therefore, we should use human rights to make states more democratic, so therefore they will be peaceful. That's sort of a counter argument, right, to what I've been presenting. If we want the world to be peaceful, we should make it more democratic. If you dive into this literature, which is widely cited about countries not democratic countries not going to war, it turns out that a democracy is not synonymous with a human rights respecting regime. The democracy that is measured in these studies is actually not about civil rights. And the coding makes this absolutely clear. Democracy in these studies mostly means free and fair elections, which has a little bit of overlap with international human rights. But the mass body of international human rights obligations aren't related to elections and aren't related to these measures of democracy. All right, so let me wrap up. I can say a lot more about the democratic piece if you're interested in the political science literature and what the democratic piece says about how international law should encourage peace. But I'll conclude with this. So even as the world faces global financial uncertainty, cyber warfare and conflict, terrorism, climate change, growing authoritarianism, and other risks, peace among nations remains of fundamental, overarching importance. Indeed, threats to peace, to say nothing of war itself, hinder our capacity to cooperate and make progress on all of those other global issues. How to ensure peace among nations? Today, on the geopolitical side, there's threat from the rise of China and emboldened Russia, weakening of Western institutions and alliances, not to mention Iran, North Korea, and so on. But there's also a threat from this unexpected source, the rise of international human rights law. Human rights law wants to transform sovereignty, to make state sovereignty conditional upon states fulfilling their obligations to their own people. That laudable objective comes at a price. Weakening the territorial-based system of state sovereignty unsurprisingly generates territorial uncertainty. Human rights also tear at the system of international law as a whole. By declaring a vast array of human rights as protected through international law, the hope over the past several decades was to harness the power of law, the power of legal obligation to ensure that individual human rights would be protected. Again, a laudable goal. But international law is not a strong system of law. It depends on decentralized enforcement. It depends on reputations for compliance. It depends on the UN Security Council. These are not unlimited resources. And human rights tears, to some degree, at this fabric. To create the conditions for peace among nations, international law should refocus on a core set of legal obligations designed to facilitate international cooperation and promote international peace and security. And so after delivering what was undoubtedly an extremely controversial lecture, I'm happy to take your questions.
So we do have time for questions, and if you have one, if you can raise your hand, and I will recognize you, and Ryan will try to, actually up here you can press the bowl, so we'll go to Judge Hagedorn first, and then we'll go to the back second. Hold it, press the rim, and hold it down. Thank you.
We'll use this. Here we go. All right. I'm curious if you could comment on the rise of nationalism and populism and how that affects your analysis. I suspect one could argue it could go both ways. On the one hand, maybe decreasing general respect for the international law regime, and on the other hand, maybe helping to further your goal of a more narrowly focused international law regime. So I'm curious as to your thoughts.
That's a great question with a bunch of moving parts. So I think the rise of populism and the increase in authoritarian regimes, particularly the second one, right? There's a rise in authoritarianism, Turkey, China, Russia, Venezuela, and so on. I think that cries out for a response for human rights. But notice, a human rights response does not have to be from international law. There are many ways to protect human rights. We can use diplomacy, right? We can use soft power. We can use a lot of tools that are not the hard tools of international law. So I think some of the dangers posed by populism cry out for a response and a forceful response. I think sometimes we overemphasize international law when we might look at other ways of responding to them. But your question had another aspect of it too, right? Which is this maybe good for my thesis? Because it might mean the world's countries are sort of happier to return to sort of a less human rights-oriented approach to international law. Is that correct?
Or at least more distrustful of an expansive international law regime.
I think that's right. If you read this book, The Thucydides Trap, one of the things that Graham Allison says is, one of the mistakes that ruling powers make are not understanding the increase in the power of other countries. I think it would be terrific if we had binding international law that made respect for women's rights, respect for the rights of children, respect for the rights of minorities. If we could dictate that through binding international law and the world's countries would follow, I would absolutely, sign me up. But I think, as you point out, with the rise in a variety of states with very different political structures and very different self-conceptions, and often with the support of their own people, right? That's the rise in populism. It may be beyond the power of international law at this moment to dictate how countries organize themselves domestically. And in a kind of broad normative sense, that's terribly sad. I think human rights are, some of the most valuable moral and sort of domestic rights that we have, and I would like to see those grow in other countries as well. But we need to be clear-eyed about what harnessing human rights to this superstructure called international law is going to do to it. And I think, the rise of China and Russia means that it's they view the reorientation of sovereignty around human rights. Their view of that is, hey, just when we got to be sovereign, just when we joined the sovereignty club, guess what? They changed the meaning of sovereignty. And since we're not democracies, we're not fully in the club anymore. Now, I don't think that's the motive behind this transformation of sovereignty, but do try to see that perspective, right? That we are changing this idea of sovereignty in a way that favors one kind of political structure over others. And if that's not your political structure, it's not as exciting. So it's a great question. I hope I did some work in getting at it.
Ryan, if you can take the microphone back there. Thank you.
As a professor of international law at Vanderbilt, do you ever draw parallels for your students studying under a microscope our own division in our own nation state, and how we as professors, as lawyers, as politicians can learn application for positive change at the microcosm level to the macrocosm level? I mean, we are so divided in our own country right now with the two-party system. We have to clean this up here first, but again, it's a good thing that as students we can focus on. How do we create collaboration? How do we create communication in our own divisiveness?
I wish that I could say the answer to that question is yes, because it's such an excellent observation. But the answer to that question is no, that I have not done that in my classes at Vanderbilt. But I like the analogy a lot, right? How do we overcome these basic differences that divide us within political systems, right? Dividing us within our own democracy here, but also dividing us as a world, trying to cooperate. How do we overcome that? We have a growing LLM program at Vanderbilt, and there's actually been nothing more helpful to me in teaching public international law than having a really bright, engaged group of students from China actually in the classroom with my kids from Vanderbilt, because over the course of the semester it introduces them to a set of perspectives that aren't entirely obvious. Because most of us tend to believe our own country is very well motivated, and I think most of the people that run this country are very well motivated. But sadly, that's not the perception out in the world. And you're right, it is a little bit like the political divisions, right? We tend to see our own party, and we tend to see our own, the people who agree with us in a very positive light, and we're, find it increasingly difficult to criticize people on the opposite side. So thanks for the great teaching observation.
Let's take a question here. If you can press on the rim of the microphone and hold it down, the rim. Right, and hold it down. Go ahead.
Holding? Okay.
Hi, Nate Kirshner.
Nope. It's not working. There we go. Hi, Nate Kirshner. I'm on the board of the International Practice Section for the State Bar of Wisconsin here, so you're very welcome here. And I just wanted to say it's been a great lecture. You seem to propose sort of a retrenchment towards international peace and security and international law away from the human rights aspects. How do you feel about the other enforcement aspects that are available within, arguably, the international human rights or international humanitarian law world, like the ICC? You said you were for treaties such as, a treaty that would guarantee the rights of women that could be enforceable. Here we have the ICC, which to the signatories should be enforceable, but then, for example, President Bashir wasn't apprehended in South Africa. That's one question. The other, I'd like to ask sort of more of a practical question. Being at Vanderbilt, being in Tennessee, which is not on the coasts, it's not part of one of the hotbeds of international law.
We don't even have a lake.
Well, see, there you go.
Right.
You've got a river, though. The river's nice.
We got the Mississippi on the other side, though.
It may as well be. But how do you, are there things that you do within the community to expose people to international law and these kinds of concepts and get people involved in them? Because that's something we really work with the State Bar, and I'd love to exchange some ideas about that. Thanks.
Great. So the International Criminal Court. So when we go back to, we think about 1928 and we think about the effectiveness of the Kellogg-Briand Pact, one of the things that it did well was lay the groundwork for some of the Nuremberg prosecutions. So in that sense, too, right, that 1928 agreement did wind up having some real-world effect, right? Some people wound up being put in prison for aggressive war. Now, it's not the most beautiful piece of lawyering, I have to say, right? There was a little bit of hand-waving that managed to turn the Kellogg-Briand Pact, which is like 2 paragraphs long, into the basis for imposing criminal sanctions. Not perfect, but it did the work, which is, that tees up your question, which is about, what about international criminal law as a method of enforcement, and particularly ICC? I think the International Criminal Court has been, very polarizing and in some ways very counterproductive. It's called in many places the International Criminal Court of Africa, because almost all of the people that it has prosecuted are from Africa. And there are a lot of human rights violations in international criminal law in, the Middle East, arguably at the hands of the US and the Allies, Palestine, Israel. There are a lot of places where violations of international criminal law are at least allegedly occurring. And so where is the ICC focused? It's focused on Africa. Right? That's not making Africa very happy. And it goes back to this problem of sort of selective enforcement, right? You can't, the United States is not a party to the ICC, right? And I think your odds of actually prosecuting someone before the ICC from a powerful, particularly a P5 UN Security Council veto holding country, are extremely slim. And so the ICC winds up looking and feeling like a court for a certain kind of defendant, right? Not a neutral court that applies across the globe to all violators of international criminal law, but just applies to some. So that's, one piece of the International Criminal Court. Another, again, I agree with the objectives of the court. I hope these people who are convicted, I'm extremely happy to see them where they belong, which is behind bars. But notice, even in the areas where it's effective, it can reduce the ways of removing people from power, right, who have been violators of international human rights. So imagine that you're the president of Syria, right? 30 years ago, you might have been able to take some kind of buyout that allows you to live on a South Pacific island somewhere, right? Someone would come and offer you this deal and usher you kind of out of Syria in a helicopter. Well, today you've got to worry about the ICC, right? And I'm not making, and there is a school of thought that says the ICC is making it harder to transition people out of power, because they should worry about going in front of the ICC. They should worry about going to prison. So if your choice is between facing the ICC, or hanging on to your tyrannical, despotic regime and continuing to abuse the people in your own country, sadly, some people will choose the latter option. I haven't done as much as I should in Nashville, but I agree. We need to do more. I think it's vitally important that we have these conversations, not just in Washington and New York, but here in Milwaukee and Nashville and everywhere else.
So I think we're going to leave it there in terms of the full group Q&A, but let me say three things in conclusion. One is that we will have a reception right outside the Lubar Center here in the Zilber Forum, and if you have other points that you want to press on Professor Wuerth, I'm sure that she will be glad to engage with as many of them as possible. Second, I want to thank all of you for coming to this annual Boden Lecture. It really is inspiring to see so many people in the Marquette Law School community who are interested in these broader topics in the law. And third, and most warmly, I want to thank Ingrid Wuerth for delivering to us this afternoon a most engaging and indeed somewhat provocative Boden Lecture. Thank you.